So what I've added into the next set of slides is not necessarily case law. So I want to tie in, going to the next slide, some of the issues that I saw. For example, we talked about FMLA. And so what I've tried to do is I'm not going to go exhaustive through these slides, but I wanted to demonstrate to you guys how it's going to interplay with some of these decisions that we just talked about. So the first one is the Families First Coronavirus Response Act. And this one's tying into FMLA. And what you need to know is that they have passed this provision that went into effect in April of this year, and it's going to affect how you get FMLA in response to the coronavirus. And this is set to be applicable and effective through the end of this year. Going to the next slide, it's kind of smaller and harder to read, but basically as an employee, what this change is doing is, as you can see, there are two situations that could apply under this additional FMLA. And just so you guys know, I went to the website of the Department of Labor and they have so much information, but this stuff stood out to me since we were talking about FMLA. So in the first instance, you have the paid sick leave if it's affecting you, and you can see it's going to be at your regular rate. In the second one, you'll see in between the the second one is talking about 2/3 of the rate. And this one is going to be more applicable to the situations where it's not necessarily you, but it's someone related to you, and it deals with you having children and the school or the child care provider is shut down. Then it's going to kick in the second one. Now, if you look at the very bottom of it, you see the and. So let's go to the next slide and you'll see, in addition to those two possible ones, you have this expanded one as well, which also kicks in at the 2/3. So you have to be employed for at least 30 calendar days. But in this situation, they're talking about if you have a bona fide need for leave because you don't have childcare, because your children are no longer in school because it's shut down, then this is when this particular provision is supposed to be kicking in. Now, going to the next one, the same fundamental rules apply. You have to try and give your employer as much notice as possible. And you have to look at your college's policies. I'm sure they're going to get updated to account for some of this. And you're talking about the notice and the supporting documentation that you may need to provide. Now, going on to the next one, the Department of Labor provided this expansive list of the qualifying reasons for leave. And like I said, I won't go through all of them, but as you can see here, you get diagnosed, you are subject to an order. What you need to remember here, and you can look at these slides after the fact, I believe they'll be provided to you, but notice the numbering 1 through 6. It's going to start playing into the next slide when they're talking about, okay, if you get a qualifying reason, here's how the duration's going to last, right? And going on to the next one, you'll see this is how the pay is going to be calculated. And one thing to note, notice how there are maximum amounts when they're talking about your regular rate or the applicable minimum wage, whichever is higher, but then it says up to 511 or 5,110. So it's not going to be a huge amount, but this is what has been put in place so far. Now, going to the next one, I went to the EEOC's website. They have a ton of information as well. Remember, we talked about the ADA. I think that's going to start kicking in as well. And so what the EEOC was trying to do was, a fear I think that they're getting from employers is, how is this interplay between this pandemic and the ADA and the possibilities that people are going to claim disability? So at the end of the day, the EEOC answers a multitude of questions. I just picked out the ones that happen to catch my attention. So one thing to note at the bottom is you as your employer is going to have to maintain any information if you do become infected or suffering from corona. It remains a confidential medical record in compliance with ADA. Going to the next one, it's talking about the CDC providing guidance and how employers can ask particular questions to determine whether or not an employee poses a threat to the health in the workplace. Going to the next one, you can see a lot of times that in a lot of employment places now, it's becoming more commonplace for body temperatures to be checked. And so one of the things the EEOC was addressing is the employer is permitted to take your temperature before you are coming back into work that day. I'm not sure how many of your employers are doing it yet, but the EEOC is saying that's okay for them to do. Going to the next one, obviously, if you become ill, the employer is going to be able to ask you to leave the workplace so that you don't infect others. And so the employer is going to be within their right to do that. And going to the next one, just like with FMLA, the ADA is going to allow employers before, if you do become infected, the employers are going to be able to ask you to bring a doctor's note certifying that you're fit for duty. Just like under the ADA, just like under the FMLA, depending on the reasons that you took the leave. But the thing that the EEOC is also trying to warn the employers in this, if you look at the bottom two, there's a scarce resource of doctors. It could be hard. So there's going to have to be new approaches to determine what's going to qualify as a fitness for duty. Next one, I found this interesting because I've been hearing a lot about antibody tests. The EEOC is saying, look, the employer, no, you cannot do that. It's not going to be job related. It's not a business necessity. So as of right now, there can be no requirement for any sort of antibody testing by the employer. And the next one you'll see, this is more important as far as your personnel file. So your medical records are supposed to be kept separate from your personnel file. So if the employer has any medical information, it's got to be outside your personnel file to protect the confidentiality. And so this is going to include, as you see at the bottom, if you provide a statement that you believe that you may have it or suspect that you have it, or any notes that the employer takes on questioning you about any symptoms, it's going to have to be stored with your medical files and away from your personnel file. And if we go to the next one, you see that one of the questions that was posed on the EEOC's website is, okay, well, can I get an accommodation under the ADA if I'm trying to avoid exposing a family member who's at high risk? The answer from the EEOC is no, you can't, because the ADA is not requiring that an employer accommodate you as an employee without a disability based upon disability-related needs of a family member. So that's not to say that your employer can't be more flexible with it. So that takes us to the end.